Hi, my name is Carl Pearson. I've been a lawyer for more than 40 years and spend most of my time defending foreclosure actions and bringing lawsuits against banks as counterclaims or in wrongful foreclosure actions. I'm licensed in New York, and with local counsel I'm able to represent homeowners in the courts of the 49 other states. This video, number 42, is a very important one. It's entitled Homeowners Can Sue Banks to Cancel Mortgage or for Wrongful or Fraudulent Foreclosure and Punitive Damages. Now, what I'm going to say is important to every homeowner who either has an existing mortgage or has lost his or her home because of a foreclosure or a threatened foreclosure. Millions of present and past homeowners are owed huge amounts of money and punitive damages for what they have done to homeowners, for what the banks have done. Now, millions of homeowners may be able to cancel their mortgages by doing what I am going to outline to you, to make sure that I say everything I want to say exactly as I want to say it. I'm going to pretty much read this prepared script to you. Now, applicable situations. I'm directing my video to persons who fall into any of the following situations. 1. You lost your home through foreclosure sale. 2. You defaulted in a foreclosure action brought against you. 3. The bank refuses to give you a reasonable loan modification agreement, including a lower monthly payment and a reduced principal amount of note. 4. The bank has encouraged you to make payments through false promises. 5. The bank may not be the owner of the note and mortgage. 6. The bank may not have possession of the original note and mortgage. 7. The bank may have registered the mortgage with MERS and willfully destroyed the note and mortgage thereafter. 8. The bank evicted you from your home. 9. The bank engaged in predatory lending practices, such as having you borrow on terms that the bank knew you could not repay, that is, or for example, giving you a very high adjustable rate mortgage. Now, my list is not complete. There are various other situations you might have which should be added to the list. Also, I do not mean to say that you automatically win if you have any of the above situations. What I'm saying is that the tide is turning against the banks and their mortgage lending and foreclosure practices, and you should speak to an experienced foreclosure litigation attorney about your specific set of circumstances to see what you should do, if anything. Illegal activities by banks. The already known illegal activities by banks, as well as the recently revealed illegal activities by banks, provide a broad range of potential claims for damages, punitive damages, and cancellation of mortgage, and or a right to a reasonable loan modification agreement. Now, these are all very important things. These illegal activities include 1. A refusal to grant a reasonable loan modification agreement. 2. Willful destruction of the original note and mortgage. 3. Commencing foreclosure actions when they do not own the note and mortgage. 4. Commencing foreclosure actions when they do not have possession of the original note and mortgage. 5. Filing false affidavits in court. 6. Filing purported affidavits that were not actually notarized. 7. Falsifying their right, that is their standing, to commence foreclosure action or to sell your property. 8. Commencing a foreclosure action when they had no right to settle the action through granting a homeowner a loan modification agreement. 9. Breaking into your home while the homeowner is in legal possession of the home. 10. Using false appraisals and falsified financial information to give you a mortgage. 11. The bank won't tell you who owns the note and mortgage or whether the originals are even in existence. 12. Breaching the bank's promise or covenant to you, implied or inherent in every mortgage, that it will act in good faith and deal fairly with you as to the mortgage. And 13. The immediate assignment of your mortgage to a non-bank, which could be a breach of the implied covenant of good faith and fair dealing. So we have an enormous variety of possible claims that could be made for almost anyone that is a homeowner with a mortgage. Now, the homeowner's remedy. The remedy for homeowners is to file an action against the bank if the circumstances are appropriate. You need to talk with an experienced lawyer about your circumstances to ensure that your claims are meritorious. The nation's major banks are in disarray right now, with enormous pressure on them from the courts, the 50 state attorneys general, the investors themselves in the mortgages, Congress, the president, the major media, and hopefully from homeowners through appropriate lawsuits against the banks. Now is the time to commence a lawsuit against the bank. Some observations about a lawsuit. A lawsuit would have the following advantages. One, you could obtain discovery to determine whether the bank is the owner of the note and mortgage, whether the note and mortgage are in the bank's possession, whether the note and mortgage were willfully destroyed through registration of the mortgage with MERS, and all assignments, and whether the assignments were properly recorded. Two, if the bank defaults in the litigation, you could wind up having a judgment declaring the mortgage to be unenforceable and to be removed from the official records as a recorded mortgage against your property. Three, the bank may decide to give you a reasonable loan modification agreement in order to end the lawsuit. Four, the bank will have to spend perhaps $20,000 to $100,000 defending against your lawsuit. Five, you could wind up with punitive damages amounting to no more than 9 times the amount of actual damages you prove. Now, what are the bank's initial responses to a lawsuit? That is, what are the options that the bank and its attorneys have? Initially, they, number one, can decide to defend vigorously. Two, they may default, but don't count on that. It's too good to be true. Three, even though 95% of the homeowners default, the banks will not, believe me, ever reach that kind of a percentage. But hopefully they may default in 5% of the cases. I'm just guessing at that one. Three, settle for money or a loan modification agreement just to terminate the lawsuit. Four, file a counterclaim foreclosure action or sell the property in states not requiring a foreclosure action if you are behind in your mortgage payments. Five, move to dismiss your complaint. Six, move for summary judgment saying that the facts don't justify your lawsuit. Or seven, seek discovery from you. Those are the basic immediate options that the bank has. Now, your litigation costs. The costs to start a lawsuit of this type could be as low as $5,000 to $6,000, including the cost of local counsel. If the lawsuit does not proceed satisfactorily from your standpoint, the bank could undoubtedly be willing to have you dismiss your action against the bank, which would enable you to limit your litigation costs. You need to look at the amount you could win or the value of a loan modification agreement in relation to the cost of the lawsuit. In many cases, a lawsuit is really a no-brainer. You should discuss this with your attorney. Now, there's a strategic lawsuit for homeowners who need to stop paying their mortgage. It goes like this. If a homeowner in a judicial foreclosure state, of which there are 23, sees that he or she cannot continue paying an excessively high monthly amount, the homeowner should think of stopping payment of the mortgage and bringing suit against the bank alleging some of the claims listed above. Spell out your need and qualification for a loan modification agreement in the complaint and hope that the bank will grant a loan modification agreement to be able to end the lawsuit. This would have the advantage of reducing the amount owed on the mortgage. The bank would counterclaim for foreclosure, and at least in New York, the foreclosure would wind up in the settlement part where the bank is required to negotiate a loan modification agreement in good faith, and that probably applies in various other states as well. So if you have any questions, please give me a call. My name is Carl Person. My telephone number is 212-307-4444, or go to my website, carlperson.com, and I'm able to represent homeowners in the courts of any state in the country through use of local counsel.